Can I just say something about Andrea?
Welcome back, folks. So we had cause for celebration this Christmas when we received the word that the Massachusetts Post Commission had voted to decertify Robert Devine. We took a look at that part of their decision, and it was glorious, wasn't it? So validating to have it kind of reaffirmed for us that everybody thought Robert Devine was a lying liar who lied. Nobody bought his outlandish explanations. Nobody was impressed with his demeanor and comportment on the stand. And nobody was impressed with his efforts to smear Sandra Birchmore and pretty much anyone else he could find to throw under the bus to try to divert blame and suspicion away from himself. And, the Christmas season is not quite over yet. It is not yet the Epiphany, January 6th, the final formal end of the Christmas holiday, that 12th day of Christmas. So we have a little bit more to celebrate here. We got a little bonus celebration because we got the hearing officer's decision as well. When we first did our stream on the outcome here, what we had was the post commission's review of the hearing officer's decision and their determination that, we think it was justified. There's no legal grounds to overturn it. But we didn't have the hearing officer's decision itself. And that's the fun one, because that's where you get what exactly the findings were, what were they based on, and things like that. So that's what we're going to be taking a look at today, guys. Let's go ahead and hang on to your hats. It is a little bit long. It's somewhere in the ballpark of 30 pages, so quite a bit longer than the decision that we looked at from the Post Commission. Oh, it's double spaced, so maybe not quite so bad. But this one is going to be a little bit more in depth than what we heard before, as far as why the hearing officer decided that decertification was warranted and appropriate in this situation. So let's go ahead and take a look at the initial decision. So we have some preliminary introduction. The Act relative to justice, equity, and accountability in law enforcement in the Commonwealth was signed into law on December 31st, 2020. In 2021, the Massachusetts Post Commission was established to certify and decertify all police officers in Massachusetts. The commission was also authorized to revoke or suspend an officer's certification or to order retraining for an officer. On July 1st, 2021, pursuant to the Act, the respondent, Robert Devine, was automatically certified as a police officer in Massachusetts. On November 22nd, 2022, the Commission directed its Division of Post Standards to open a preliminary inquiry to investigate the above allegations against the respondent. On January 16, 2024, the division issued an order to show cause, ordering the respondent to show cause why the commission should not revoke or otherwise take action against the police certification of the respondent based upon the allegations discussed below. On February 5th, 2024, the respondent answered the OTSC. Proceedings were conducted before the Honorable Kenneth J. Fishman, retired Massachusetts Superior Court judge, and a hearing officer appointed by the commission. Procedural background. Between March 24th and May 2025, 10 pre-hearing conferences were held principally to deal with the extensive discovery process relating to this matter. 14 months they spent on discovery and still couldn't get it right. Still couldn't get it right. That was like the biggest impediment, the biggest concern about justice being done in this particular proceeding, because they just couldn't get their shit together when it came to obtaining the relevant files and documentation and providing all of those to the defense in a timely fashion. Due to the nature of certain evidence and allegations, a protective order was entered on March 26, 2024. A supplement to the protective order was signed on January 6, 2025, to extend the scope of the protective order to newly discovered material and all future discovered material. Following a final pre-hearing conference, the hearing officer issued a decision on the parties' motions in limine relating to the admissibility of certain proposed exhibits. An evidentiary adjudicatory hearing was held on June 5th and 6th, 2025, and on July 15 and 16, 2025. What's our footnote say? Standard rules generally apply. All proceedings were recorded but closed to the public for the reasons stated in orders dated May 30th and June 4th, which were issued pursuant to this matter's protective order and supplement. Let's check that footnote. It's just citing to the rules that allow them to do that. 4 witnesses testified at the hearing. Donna McNamara, Chief of Police of the Stoughton Police Department. Brian Holmes, Chief of Police of the Kingston Police Department. Hailey Hogan, former participant of SPD's Explorers program, and the respondent himself. The division offered 14 exhibits, 12 of which were admitted. The respondent submitted 19 exhibits, 8 of which were admitted. Both the respondent and division opted to submit closing memoranda in lieu of making closing arguments at the hearing. Pursuant to the order of the hearing officer, closing memoranda, including proposed findings of fact, were submitted by the parties on August 25th, 2025. That was when the hearing officer made that funny. I'm not going to need yours, Mr. Devine. It's fine. Don't even worry about it. I'm not going to need your proposed findings. And, it's like a joke and it's a ha-ha, and yet how true it was, wasn't it? Allegations. The OTSC alleges that the respondent engaged in a pattern of unprofessional police conduct that may escalate, and that he has repeated sustained internal affairs complaints for the same or different offenses. As charged in the OTSC, the first set of allegations relate to the respondent's 2015 suspension and demotion. It is claimed that Devine engaged in several instances of misconduct in late 2014. He is alleged to have twice improperly ordered a subordinate to investigate a potential crime, redacted, and was untruthful in that he failed to disclose material facts to the Massachusetts State Police who were investigating alleged violations of the blank. We kind of already know what they're talking about here. This was the allegation that he was involved in an extramarital affair. He claimed to be receiving harassing messages, communications on social media, escalating up to somebody sending flowers to his home with a note. He relied on that to get a restraining order against his affair partner, but continued to have a relationship with her all the way up to, while this investigation is going on. He's continuing to communicate with her, have sex with her, while he's got a protective order against her. So she gets prosecuted for violating the protective order. And at that point, this additional context comes out that he's, not terrified. He is, in fact, continuing to voluntarily engage with her. Give me 1 second here. I got a cat that's trying to tear my feet apart. Hey, Gus, stop that. All right, I got my foot back. So anyway, this was the context, remember, where the hacking allegations first came out. This was his first explanation for his devices had been hacked, right? And like every single social media account and everything that he's ever had, they all got hacked. It wasn't him that was sending out communications and so forth. This is when that first came out. And so I gotta say, it does really cast the whole situation in a bit of a different light for me, because there clearly seems to be a setup here in terms of the violation of the restraining order, right? He's having a relationship with her, and then he goes and reports her, and she gets arrested and charged. And then they discover, hey, you're the one that was like initiating that, and they ended up dropping the case. But it does make me wonder if the whole grounds for getting the restraining order in the first place, he had a little something to do with that. And that's why the hacking came up. I don't know, but This guy has given me no confidence to think that he wouldn't do completely underhanded and dishonest things to protect his own interests in a situation. And, finding your way out of an affair in a way that will allow you to present some type of defense, no matter how, ridiculous it is to your wife. Seems like the kind of thing this guy would do. So that's the redactions. We already kind of know what this was about. His alleged misconduct resulted in multiple sustained allegations for which he received a 60-day suspension and a demotion of 3 ranks from deputy chief to patrol officer. The second set of allegations relates to an individual identified in this decision as well as on the record in this matter by the initials SB. It is further alleged that from 2020 until early 2021, Devine engaged in further misconduct relating to his relationship with SB, a former Stoughton police explorer. The division maintains that Devine met with SB for a sexual encounter while he was on duty as a law enforcement officer, that he had inappropriate communications with SB through Facebook Messenger while on duty, and that he was untruthful about his misconduct during the related internal affairs investigation. Although he retired from duty while the internal affairs investigation was pending, SPD again sustained multiple allegations against Devine. Now let's get into the good stuff, the findings of fact. That was all background. Now we get into what the hearing officer thought based on what he heard. Based on the evidence adduced at the hearing officer makes the following findings of fact. And now remember, too, this is a retired Superior Court judge. He has done this in contexts in court, in civil cases, in criminal cases, where you have the expectation that parties are going to appeal it. It's going to go up to a higher court. They're going to evaluate it. Judges learn. They learn through this process how to insulate their rulings, how to present them in the way that is going to ensure that the likelihood that it's going to be reversed is low. So with that in mind, Devine's professional background. Devine testified that he began his public service career in 1993 when he joined the United States Coast Guard, where he served 7 years on active duty and an additional 3 years in the reserves. He reported that during his military service, he received multiple letters of commendation recognizing his performance. Following his Coast Guard tenure, Devine was put in charge of the Marine Environmental Response Unit for the city of Boston, a role that required him to relocate frequently. Devine transitioned to law enforcement and was appointed as a police officer at SPD in 1999 after graduating from the police academy. So he upgraded from the Marine Environmental Response Unit. Honestly, I don't trust this guy to protect the horseshoe crabs. Like he doesn't belong anywhere near any of this. But he got himself into law enforcement. In 2001, Devine was assigned as the juvenile officer. He was promoted to sergeant in 2004, lieutenant in 2006, and deputy chief in 2008. Devine served as deputy chief, which was second in command at the SPD, until 2015, when he was demoted to patrol officer due to sustained charges of misconduct. From 2015 until 2021, when he resigned, Devine served as a patrol officer, at first working in dispatch as a desk officer, and later returning to a regular patrol shift. The respondent was admitted to the Massachusetts bar on January 11, 2021. While at the SPD, Devine participated in various community outreach programs. He was a founding member of the Organizing Against Substances in Stoughton Coalition, an initiative aimed to address substance and alcohol abuse within Stoughton. The program was credited with bringing approximately $10 million into the community for substance abuse prevention, so he figured out how to get grants. Devine also served for several years as the officer in charge of the Police Explorers Program. The Explorers Program was a structured environment where middle school and high school students, who were typically at risk, could gain exposure to careers in military and law enforcement. As head of the program, Devine organized the program to resemble a police academy with both classroom and physical exercise components. 2014 misconduct and resultant discipline. The respondent testified that at some point in approximately 2014, when he was serving as the deputy chief, he was having marital problems and separated from his wife. During that time, he began to have an extramarital relationship with a civilian. When Devine attempted to reconcile with his wife, there's a whole bunch that's redacted, but we know this is the background about the harassing messages that he supposedly got and the restraining order and so forth. He testified at the adjudicatory hearing that at the time of these events, his social media accounts and those of his wife and son were broken into, and text messages were being sent that he never sent. Indeed, he claimed that he filed complaints with the various social media providers, but that the problem was not resolved. It is noteworthy that the respondent testified that his problem of others falsely attributing social media messages to him went on from approximately 2015 to 2020. It is noteworthy, isn't it? And by noteworthy, that's a really nice euphemistic way of saying this is a whole bunch of horse shit and not a single person on the planet believes this. You have to think we're incredibly stupid to think that we're going to believe this. The hearing officer deems that this testimony in the context of this matter is curiously convenient for his defense of the allegations of his conduct involving SB discussed below and inherently credible. Curiously convenient. This is some snark. Getting a little snark from the hearing officer. You really do think we're an idiot, don't you, Mr. Devine? He's basically saying that in his choice of words here. It's very nice of him to insert this curiously qualifier in here because it's not curious at all. It's actually completely understandable that a lying sack of shit would make up something that is completely unbelievable and expect you to just swallow it and say thank you, sir. That's how people like this think. They think I said it, therefore you're stuck with it. You can't disprove it. No, but I can find that it lacks consistency with reality, with normal everyday experience, with the way that people all across the world interact with social media and find ways to deal with problems, the way that hacking works, the types of tools that are available to be able to extricate yourself from that type of problem. We can actually find that this is highly, highly implausible. And the saying goes, extraordinary claims require extraordinary proof. And I don't think we even got any proof beyond Mr. Devine saying so that he ever did make a single complaint to anyone or do anything at all to try to resolve this serious hacking problem that he claimed to be having. Didn't he even name a name at one point? He tried to identify somebody as being associated with one of the messages, like his brother-in-law or something like that. And no proof of anything, but he said so, and therefore we are to buy it. But clearly, the hearing officer did not. He finds it inherently incredible. As the respondent argues, the investigation in this matter is not above criticism, particularly as it related to the Facebook messages at issue here. Devine contends that at all times relevant to the 2021-2022 Internal Affairs investigation, he did not have a Facebook or Facebook Messenger account, and in fact, the division did not introduce any records from Facebook that established the existence of such an account. Even Brian Holmes, the author of the 2021 SPD Internal Affairs report, specifically made the following recommendation, which was not followed by the division. So they're finding fault with, this is probably like some kind of subpoena process or something like that, warrant, to go to Facebook to get account information. I don't know what the specific recommendation was, but I have a little bit of fault to find with the finding fault here, which is that to be able to track an account to him, you would need to know what his IP address is. were, like, likely you would need something like that because you can make up an email account. You can just make up an email account on a free service like Yahoo or Hotmail, whatever, and use that to set up a Facebook account. And so there's not necessarily a good identity-based way to track an account, just through that type of information. So you would need device information to be able to track it to uh, Mr. Devine. And it's not clear to me that they ever had that or would have the ability to get that necessarily through this process. So would be nice to know what the recommendation was, but we don't get to here. As discussed below, however, there is other evidence that undermines the respondent's claim that he did not have a Facebook Messenger account during the relevant times and supports the conclusion that he was the author of the inculpatory messages with SB. According to Devine, the harassment in 2014 had escalated to the point where his entire family had to change their contact information and suspend their social media accounts. Initially, Devine was unsure of who was responsible for the online harassment. In response to the harassment, Devine improperly used his official position by instructing one of his subordinate officers to perform a forensic download of his personal cell phone records to identify the person prior to the opening of any official investigation. Afterwards, flowers were delivered to Devine's home along with an inappropriate message. As the respondent acknowledged in his testimony, upon identifying the individual who sent the flowers as his civilian girlfriend's friend, he then proceeded to make contact by leaving the individual a telephone voicemail and sending her an electronic message despite that blank. Is this that he had the restraining order against her? So I want to back up real quickly here because, okay, so what he did, he directed one of his subordinate officers to perform a forensic download of his personal cell phone records to identify the person he's saying hacked him prior to opening any official investigation. So I'm assuming that this would be similarly to identify any IP or any device that doesn't belong to him that was accessing these accounts to perhaps get login information or something like that for these accounts through his phone. That's what it sounds like he's trying to do. Now, I got to notice the time frame, the afterwards, the flowers were delivered to his home along with an inappropriate message. So it's after he starts investigating the hacking, right? It's starting to smell a little bit more like a setup. A little bit more like a setup. First you make up the hacking. Then you get the forensic download to try to establish some proof that it happened. Then you go ahead and set up the person that you're trying to get out of your life. I'm not saying that did happen, but it seems to be consistent with the way that the facts are coming out here. Now, I can't also help but notice that we heard nothing about what results did you get from this forensic download? What exactly came out of that? Because it sure seems like if it was helpful and it tended to establish that your phone had indeed been hacked, that would have been front and center evidence in this case where you're claiming, yeah, my phone had been hacked. And I was dealing with this problem for, 5 years, including all the way up to when Sandra Birchmore is claiming that we had a relationship. So factually, this is rather interesting. Due to the ongoing issues, something we don't get to know, as a result of continued harassment, MSP subsequently initiated an investigation against Devine's civilian girlfriend. However, during this investigation, Devine failed to disclose to MSP his ongoing personal and romantic relationship with the woman, despite numerous occasions on which he could and should have done so. During a subsequent internal affairs investigation, the investigator determined that Devine had continued to have sexual encounters and communicate with the woman, even though blank. Devine even spoke with the woman the night before and on the morning when MSP executed a search warrant on the woman's home and arrested her. Months later, after MSP learned of the continued relationship between Devine and the woman, all parties involved met and the resulting criminal charges were dismissed. Yeah, because, lying about stuff, failing to disclose stuff is going to tend to present a problem for a criminal investigation. So, how could this have taken place? If this is the setup, well, starts the harassment, continues to have the relationship with her. Think maybe he might be able to get into her phone at her house or get into her computer at her house, log into his accounts, and then go in and try to argue. Oh, she hacked me. See, here it is in the metadata. Gotta wonder. After an internal affairs investigation, then SPD Chief Paul Chastany sustained the following allegations: 1, conflict of interest; 2, abuse of position; 3, conduct unbecoming an officer; and 4, untruthfulness. There it is, the finding that he's a liar. How this did not, if it didn't come up during his character and fitness examination by the Massachusetts State Bar, I certainly would love to know, because that is the type of thing that you should be having to explain, give an interview about, having to overcome that as a presumption against your fitness to be an attorney in the state of Massachusetts. And if that didn't come up because he didn't disclose it, then that is something the bar needs to be looking at quite seriously. So we have a footnote here. The investigator found that Devine was untruthful by failing to disclose a material fact to MSP, namely that he had ongoing communications with the subject of the blank. It's got to be restraining order or the criminal complaint. While testifying at the adjudicatory hearing, Devine acknowledged that failing to disclose a material fact during an investigation could amount to untruthfulness. Yeah, he did, didn't he? So all the denials that, he never lied and he's totally honest and forthright and forthcoming. But by his own admission, he engaged in conduct that he himself agrees you can characterize as untruthful. So that would tend to support that finding that back in 2014, he was already engaging in untruthfulness. Devine and SPD reached an agreement after the Internal Affairs report was finalized, in which they agreed that Devine would serve a 60-day suspension and that he would be demoted from the rank of deputy chief to patrol officer. And he just resented the hell out of it, didn't he? Remember all that testimony about just his attitude when he got back? He was too good to sit at the dispatch desk, and he certainly wasn't going to be trained by somebody who hired him. And if they said he wasn't supposed to go out on calls, well, he's going to know better than them and he's going to do it anyway. He was like insubordinate from the moment he got back. He talked about Holmes taking his job and going into the office that used to be my old office. Like, he just never got over this narc injury, this little blow to his ego that he himself agreed to. He himself agreed to it, but sure did not internalize it in any way that looks at all like actual accountability. Importantly, Devine admitted that he engaged in conduct unbecoming and misuse of his position. Nothing in the agreement suggests that the remaining sustained allegations were overturned or that the investigators or chief's findings were not supported by the evidence collected. Additionally, Devine admitted during his testimony that he engaged in the reported conduct underlying the sustained findings. Yeah, he did. They made it very clear from the point of their opening statement where they said, we're not contesting the 2015. That's not what this is about. We're just contesting the later one. So he, did the best he could to try to fall on his sword and say Yeah, I did the stuff in 2014, but of course he's never going to actually say that. He's still in denial about it. So he just tried to kind of straddle that line between, we can't challenge all of it, in part because you conceded it at the time. Makes it a bit tricky to come back now after the fact when you didn't exercise your rights back then, to try to say now that there's some kind of problem with that determination, and also to try to make you look reasonable. Like, oh yes, this one thing happened, but then I had a target on me, but he just couldn't do it in a way that wasn't always depicting himself as the victim. He just could not figure out what accountability looks like, and then mimic that. It was beyond his skills. The hearing officer finds that the evidence submitted at the hearing supports these findings and demonstrates that Devine engaged in a pattern of unprofessional police conduct that may escalate, in particular when accounting for his extensive 2014 misconduct that resulted in his suspension and demotion. So he's basically saying, the hearing officer, that the 2014 stuff alone is enough to justify decertifying him. They have more, but particularly the stuff in 2014 that he conceded is enough to make these findings that, ooh, this guy maybe doesn't belong as a law enforcement officer. 2020 to 2021 misconduct and subsequent internal affairs investigation. SB participated in the SPD Explorers program beginning in 2010 when she was 13 years old. She remained in the program until 2016 when she graduated from high school. As the respondent acknowledges, SB first met Matthew Farwell, William Farwell, and Devine through the Police Explorers program. From 2022 to 2014, Devine was the officer in charge of the Police Explorers program, and he knew SB in that capacity. On February 4th, 2021, police responded to SB's apartment for a wellness check after SB failed to show up for work. Upon their arrival, police discovered SB deceased inside her apartment. Initially, police believed her death to be a suicide, but Matthew Farwell has since been charged with killing her. Yeah, except Old Canton Police, Massachusetts State Police still consider it a suicide, don't they? Because the state has still never done anything about the death of Sandra Birchmore. It's been the feds that had to come in and take care of it. Within a few days after her death, MSP informed Chief Donna McNamara of the SPD that officers had discovered troubling communications between SB and then Detective Matthew Farwell when MSP investigators were conducting an analysis of SB's laptop, which had been recovered from her apartment. Subsequently, Chief McNamara assigned then Deputy Chief Brian Holmes to conduct an internal investigation into Matthew Farwell. It was not until several months later that other officers' alleged misconduct was incorporated into the active internal investigation. Specifically, due to communications recovered from SB's laptop and cell phone, William Farwell, who is Matthew Farwell's twin brother, and Devine were also alleged to have had inappropriate interactions with SB in the months preceding her death. All three officers resigned prior to the investigation's conclusion, and only Devine submitted to an interview. He's the only one that thought he was smarter than everybody else. Thought he could talk his way out of it. As reflected in the 2021 SPD Internal Affairs report and in Holmes's testimony at the conclusion of the Internal Affairs investigation, Holmes issued a final report which made several findings relating to Devine's misconduct. We don't get to hear about these allegations that he sustained. They're all redacted. As described above, one of the original bases for investigating allegations of misconduct against Matthew Farwell was that MSP had forensically analyzed SB's laptop, which MSP recovered from her apartment. During the examination, MSP discovered thousands of pages of communications, including text, multimedia, and social media messages on her laptop. MSP provided the raw data from SB's laptop and copies of the communications to Deputy Chief Holmes to aid him in his internal investigation. Throughout the investigation, Holmes also received raw data downloads from SB's cell phone, which was recovered from her apartment and contained electronic communications. A significant portion of the evidence against Devine was derived from SB's electronic devices. Essentially, SB's communications indicated that she had met with an SPD officer who was on duty and engaged in a sexual encounter with that individual. The officer had been communicating with SB through Facebook messages and had been using the alias Marty Riggs. We know the footnote, it's the name of a police officer from the movie Lethal Weapon. Based on the evidence adduced at the hearing, clear and convincing evidence supports the finding that Devine was the officer who was using the alias Marty Riggs on Facebook and who engaged in a sexual encounter with SB while on duty in December 21st, 2020. So we got the big picture now, the big conclusion. Let's see what that's based on. Communications recovered from SB's electronic devices indicate that she engaged with Marty Riggs on several occasions from at least November 25th, 2020 until February 1st, 2021, which was the alleged date of SB's death. So all the way up to the very end, she's communicating with Marty Riggs. The following exchange occurred via Facebook messages between SB and Marty Riggs on December 21st, 2020. We don't get to see that, consistent with the protective order. After this exchange, the two did not communicate via Facebook message until the next morning. So it kind of makes it sound like there is an arrangement to meet, perhaps. These communications are about a hookup. And so, you know, if you're with somebody in person, you don't have to talk with them over Facebook. You wouldn't talk with them until you're no longer together. And that could be the next morning. The conversation on December 21st demonstrates that Marty Riggs and SB planned to meet for a sexual encounter, and together with other evidence supports the conclusion that they did actually meet. In fact, Devine's testimony supports that the timing reflected in the conversation aligns with an actual encounter between the two individuals meeting at the Chateau Restaurant. Devine testified that both Goddard Hospital and a Chateau Restaurant are located in Stoughton. He also testified that the two are within a 10-minute drive of each other, as reflected in the text messages, something we don't get to see. Of note, according to the SBC attendance roster, something else that we don't get to see, but we can just, I think, conclude that Devine was on duty that day. This was his testimony about claiming that he's only been to the Chateau Restaurant, like he's gone to investigate other things there, but he himself, didn't really go there. And there was an issue about trees around the area. He denied that. The implication seemed to be that this is a real concealed area, where if you were kind of just looking for somewhere to hide where you wouldn't necessarily be seen, it might be in this particular area. And he denied that. He's like, no, there's no trees in this area. So I, of course, the post-division lawyer invited us. He invited the hearing officer to look it up on Google Maps. Just look it up and see for yourself. So I did that. I'm going to share that with you guys here real quick. Let me pull it up. Because, Devine said pretty clearly, oh, there's no trees at all. Look at all these freaking trees. Look at this. This is the Chateau Restaurant right here. Chateau Restaurant, Stoughton. There's nothing but trees. Nothing but trees all around. And he was like, no, because the golf course is right there. And so you can see. So this one, tiny little space right here is the only spot where there's no trees. Okay. Everything else here at the chateau. Look at this. Look at this. Look at that. Look at that. Like, no forest. The area behind the restaurant over here, right? You come in at the front, probably go in like right over here. Yeah, that would be fairly typical. And then over in the back where the staff usually parks, they had talked about this area. Whole other little secondary parking lot over here too, quite secluded, surrounded by trees on all sides. Just look at this. And he has the gall. He has the gall to try to tell us, oh no, there's no trees in that area anyway. So anyway, I don't know if the hearing officer ever did go and look at Google like he invited us to do, but I sure did. And yeah, his denial there was not particularly credible. This was not an isolated conversation between Marty Riggs and SB on the subject of their sexual relationship. As early as November 29th, 2020, Marty Riggs wrote something. Both before and after the December 21st, 2020 encounter, they had conversations during which SB would ask something and Riggs would reply something else. On December 28th, 2020, SB advises him that blank. She says that blank. I bet this, I don't know because it's redacted, but I bet this has to do with her pregnancy and that Matthew Farwell is the father. Marty Riggs says something we don't get to see. On January 9th, a mere 12 days later, they have a conversation about whether SB and Marty Riggs can have sex, during which Marty Riggs writes blank. We don't know, but just the context, doesn't this kind of suggest, oh, hey, you're pregnant. Can we still, do our stuff? In context, these conversations strongly suggest that they had previously engaged in sexual acts. While Marty Riggs does not identify his true name in the messages with SB, several of the messages and other documents suggest that Marty Riggs is an alias that Devine used to communicate with SB through Facebook. Most important is data saved on SB's cell phone that the blank identified as blank is a person whose username is blank. It's got to be like the cop that's identified as Bobby. Didn't they say Bobby? And there was another Robert in the officer, but he didn't go by, or maybe Robbie, is a person whose username is something. We're guessing. Rob Devine Hot Cop. I mean, if it's redacted, how embarrassing is it, right? Let's go ahead and just let's just imagine the most embarrassing possible usernames that it could be. The respondent argues that the data contained in Division's Exhibit 10 suggests that SB was the owner of the Marty Riggs account. In fact, that extraction states that she is blank, that her blank, and that she is the blank, which is the same identification number associated with this username, I think, on Division's Exhibit 9. So it does seem like they do have, if they have an identification number associated with the username, then it does seem like that's something that they might have been able to further investigate. If they've got the device identification number, then they should be able to, through the IP or just some other type of resource, identify, who bought that phone and who's using that phone. So yeah, definitely seems like something they might have been able to do with the ample police powers that police have to be able to investigate crimes and other types of allegations. So don't know exactly what the detail of this is, but ultimately just seems to indicate that the extraction does not support the argument that she herself made up the Marty Riggs account and, did all this to frame him or whatever. And that there's a different device number associated with that account. Nor does the fact that SB was whatever undermine the probative value of the Marty Riggs identification evidence contained in Division's Exhibit 9. Other evidence is corroborative of the fact that the respondent is Marty Riggs. Certain messages support the conclusion that Marty Riggs works at Stoughton Police Department. As described above, when Marty Riggs was working in locations within Stoughton, SB twice acknowledged that blank, which is an acronym for police department. Similarly, SB inquired whether blank, which Devine confirmed, stands for field training officer. Got another footnote here. During his testimony, Devine claimed he was still a field training officer, even though he could not recall any active officers requiring training at the time. Given that Devine was not actively training someone at the time, the fact that Marty Riggs answered no to this question was not inconsistent with Devine's circumstances. That and the fact that Devine is just a lying liar who lies and expects you to believe something just because he said it. Him saying FTO is like a status. It doesn't matter if you're actually entrusted with training officers, which he apparently was not. You don't have to believe that. Just because he said it doesn't mean we have to accept that that's the truth. I don't buy that he's still a field training officer. I don't think you demote somebody 3 ranks and suspend them and penalize them for, being a bad cop and then put that guy in a position of training other cops how to be cops. I don't buy that at all. Other details relating to Marty Riggs support that Devine is the user communicating with SB. On January 11, 2021, Marty Riggs messaged SB stating in 2 separate messages, blank and blank. The blank appears to be a correction of the prior message, replacing the word blank. As noted, the respondent's admission date to the bar in the Commonwealth was January 11, 2021, the same day as that message exchange. Both Chiefs McNamara and Holmes acknowledged during their testimony Devine was the only person working at SBD who was admitted to the bar on that date. On the same date, SB and Marty Riggs exchanged the following messages. Don't get to see what those are, but yeah, that timing was going to be a problem. As Devine testified, once he graduated law school and was admitted to the bar, his plan was always to start his own firm. His information on the bar website reflects that he works at his own firm, Devine Law LLC. The respondent retired during the pendency of the internal affairs investigation, approximately 18 months after the exchanges between SB and Marty Riggs cited above. The respondent maintains that other evidence weighs against the conclusion that he and Marty Riggs are one and the same. Now, from an appeal standpoint, it doesn't matter. It doesn't matter if there's other evidence that you can point to that's inconsistent with the findings, as long as there is something in the record that he can point to and say, I believe that. I believe that and not this. So from an appellate standpoint, this is pointless. It is pointless to argue about the findings of the hearing officer or the internal affairs investigator in this context. But it certainly is consistent with denial, isn't it? And I can't count the times that you just see over and over and over again. Somebody who is caught red-handed, there's tons of evidence against them. They will never admit it. They just deny. And so when things like this come up, maybe there's a ruling on a motion that includes fact findings, and their response to it is routinely to criticize it, argue with it. Sometimes it's like nitpicky over really little things. It'll be something like, look, he put the wrong year in on this date. The date is wrong, and therefore the whole thing, falls apart because it's not a typo. It's some kind of, deliberate misrepresentation of the facts, which proves that he's being framed. It's like this really distorted logic that you see in these types of contexts. A lot of nitpicking, little things like that, but also just, relitigating, and typically on nothing more than just the strength of I said so. This person believed this, but that person, can't be believed because here's all these X, Y, and Z accusations that I make against that person that there's no evidence of. I just see this all the time. I really do, with people who are in that place where they are always going to deny culpability, accountability, no matter how strong the evidence is, they're always going to argue with it. And that's just what this gives. It just really gives that vibe, because you don't argue with the hearing officer's basis on the grounds that this other evidence was better. It's from an appellate standpoint, that is a terrible position to take. He testified that he had no communications with SB on social media, and certainly none using the alias Marty Riggs. The parties have stipulated that of the hundreds of thousands of pages of documents downloaded from the hard drive of SB's computer, which included calendar information, text messages, contacts, emails, photographs, and videos, only 147 pages of documents relating to a period of 69 days are claimed to be related to the respondent. 147 pages is maybe not a lot in context, but in real terms, that's kind of a lot, isn't it? That's a fair amount of communications, 147 pages worth. According to the respondent, there are no photographs or videos of the respondent on SB's computer or phone. Oh, well then we're done. If they never selfied, if they never made it Instagram official, then it couldn't have been anything. I mean, what even is this? There's no photographs or videos? Like, no, he's communicating with her with an alias. Okay. The whole point is to keep this down low. In fact, I wouldn't be surprised at all if there's communications in this text chain about keeping it all on the DL. For precisely this purpose, so that you can turn around and be like, no, it couldn't be me because she kept it on the down low. No photographs or videos, no phone call or other phone records attributed to him, no other evidence of phone conversations or even attempts to call each other, no mention of the respondent on SB's calendar, no evidence of text messages or emails between them, no evidence of his address or phone number in her contacts, nor any mention of the respondent in SB's so-called journal, which contained documents from as early as blank and as late as blank. So, right, it can't possibly be any of these things because they communicated through this down low mechanism and not on his formal email accounts or in the method that he seems to think that they should have communicated. Like, this is just such a red herring. This is such a creating an argument, a problem that doesn't exist. Like, there's no requirement that they communicate on any particular media, in any format, in order to be conducting an extramarital affair. And none of it undermines the communication that they are able to attribute between them. It's just, this is such a bizarre argument. They didn't have all this other stuff. Well, no, but you need to address what they did have and why it seems to point so convincingly at you, Mr. Devine, as being Marty Riggs, because you are the only one who fits all of these details. You're the one who got admitted to the bar on the right day. You're the one who had the meeting with her at the chateau. You're the one who was on duty on all these times that Marty Riggs was apparently on duty. So when you're unable to identify other plausible suspects that might fit those descriptions, yeah, it doesn't matter what's not there. What matters is your inability to explain what is there. So this is not confusing anybody, okay, except for maybe him. We have another footnote here. It is difficult to determine whether the journal is a complete collection of SB's documents, as it was provided by counsel for her estate. The pages come from several documents, including apparent journal entries, personal correspondence, draft correspondence, entries in notebooks, photographs, receipts, and assorted mail. There are no pages dated during the time period of the SB Marty Riggs conversations. Well, that seems to be certainly a very plausible explanation for why Marty Riggs isn't in her journal, because to the extent this is a cohesive thing that can be called a journal, she wasn't writing in it during that time frame. I mean, just kind of wild. This what's not there argument. No witnesses testified to ever seeing the respondent and SB together, despite the fact that Devine told investigators that he was careful to meet with her in public places. I love this, using it against him, using his own words against him. He's trying so hard to have it both ways. Nobody ever saw us, but you made a whole point of telling us that you would park in these public places. And then Sandra would, would chase you down, would follow you because, she's so obsessed, like all the girls are. And and you wouldn't tell her to just go away or don't bother me or whatever, because you're too nice and too professional, and you really had a duty to talk to her in case something was wrong, and all of those other implausible explanations. But his whole point was, I made a point being out where people would be able to see, so everybody would know we weren't doing anything wrong. Now you're trying to have it the other way. You're really trying to have it every possible way. The respondent maintains the implausibility of the absence of such inculpatory evidence if SB and he had the type of relationship alleged by the division and found by the SPD internal affairs investigation to have existed. Implausible that they would have this down low relationship, communicate only on this one platform through an alias, meet in all the places where she met with Devine, and not have photographs, not have ever taken that selfie. I mean, I don't know in what world this is implausible. I really don't. The problem with the respondent's argument is twofold. First, in addition to the in-person meeting on December 21st, 2020, the messages reflect that SB and Marty Riggs engaged in audio phone calls on 5 separate occasions. Oh, that's going to be an issue. If you're pointing out to it being so implausible that evidence doesn't exist, you better hope that evidence doesn't actually exist, because when it turns out there's 5 audio phone calls, and additionally, the 2 engaged in a video call on one occasion, talked on the phone and over FaceTime. Yeah, your implausibility argument has just gone up in smoke, because either you didn't know what was in the evidence, or you thought you'd mislead the hearing officer about what was there. You thought you could just say, hey, there's nothing like that in there, and hope he doesn't go and look for himself and find it. From the messages that follow the video chat, it is evident that the 2 observed each other during the call. We don't get to see those messages. Second, given the number and nature of their extensive communications, albeit over a limited period of a little more than 2 months, 2 months and 147 pages, it is implausible that someone else was claiming to be Devine, as the respondent has suggested. It is unlikely that SB was communicating so frequently, including audio and video calls and an in-person meeting, with someone she believed to be Devine who is not actually Devine. As Devine testified, he has known SB for almost 10 years. Yeah, she knew him. She knew him. If this is somebody catfishing her, pretending to be Devine, well, the jig is up. The very first time she drives up and they have the meeting in the parking lot or whatever, let alone, FaceTime call and an audio call and stuff like that. So we don't have a specific time frame here, but it just doesn't stand to reason that these things would occur over and over and over again with somebody she thinks is Devine, but actually isn't. Is somebody pretending to be him? During the several years SB was in the Explorers program, he saw her multiple days per week for several weeks each summer. According to Devine's testimony, in the months preceding her death, SB would also meet in person with Devine weekly while he was on patrol, amounting to approximately 20 to 25 encounters. Yeah, all of those times he just couldn't shake her. She was obsessed. It has nothing to do with Marty Riggs and arranging the down low sneaky links and all that. Other inconsistencies between Devine's testimony and written responses and the content of the messages between SB and Marty Riggs are also noteworthy. Oh. Consistencies between Devine's testimony and his written response and the content of the messages. So ways in which his version aligns with Marty Riggs and Sandra Birchmore talking to each other. On 2 occasions, SB asked whatever. Devine reported something else. As noted, there is also evidence that Marty Riggs knew about SB's sexual relationship with Matthew Farwell, which we don't get to see, but that's what I suspect was that previous redaction. According to his statements during SPD's investigation, SB had told Devine about her relationship with Matthew Farwell. So he admitted it. But then what? There's only a text message with Marty Riggs? So when and how did you know that? One of these in-person meetings? He didn't explain that. Where did you get that information? And why are you having this type of personal conversation with her anyway? Especially, you don't want anything to do with her. You're just trying to be polite until you can get away. In addition, Devine testified that he sometimes parked at Goddard Hospital while he was on patrol and that he was familiar with the Chateau Restaurant in Stoughton. Yes, he did. Finally, Marty Riggs stated on December 28th, 2020, which was a Monday, that he returned to work on Wednesday, which would have been December 30th, 2020. SPD's attendance roster reflects that. I think we can assume that's what Devine's schedule was. So all these things align. Yeah, that whole admitting that they had the meetups in the places where Sandra Birchmore is talking about Marty Riggs. You gotta wonder if he suspected they had his location data, knew that they could put him there, so he can't lie about it. Can't just deny that he was ever at that location, but he has to come up with some kind of innocent explanation for it. I mean, it wouldn't surprise me. They probably did have that evidence, if nothing, if not even from the IA. Like I would expect that type of thing to come out during the murder investigation of Sandra, because they would have been looking at what she was doing and who she was doing it with, in the time frame leading up to her murder. And this is 2 months right beforehand. Seems pretty plausible that this would be in the time frame that they would be looking at to be looking for, who she was having potential conflicts with that might have a motive to murder her. So a lot of common ground between Devine and Marty Riggs. So if all you've got is the absence, like that's all we've talked about so far, right? Implausible that there wouldn't be these things. That's his basis for saying, don't believe I'm Marty Riggs, despite all of these circumstances. If I were Marty Riggs, then there would be a selfie of us in her phone. Implausible that there wouldn't be. So first off, there is some stuff there. Second, when we look at the substance of what actually is there, it tends to support you being Marty Riggs. So the idea that Marty Riggs is somebody else that met with Sandra 5 times, over the phone and once over FaceTime and who knows how many times in person. And yet, this is a fake Robert Devine that she didn't know. Doesn't work because she knows who you are. The testimony of Joshua Heel during SPD's internal affairs investigation and SB's communications with her other contacts also support the conclusion that Devine had at least one sexual encounter with SB. While several of the documents and evidence suggest that SB embellished certain aspects of her personal life, including most relevant here, the inconsistent versions she gave of an alleged sexual encounter with Devine, other than the December 21st, 2021, she was consistent when enumerating her sexual partners who were also employed at the SPD. SB's conversations with William Billy Farwell, Joshua Heel, and others suggest a relationship with and personal knowledge of Devine. So this is going to the smear, right? This is undermining the smear. Basically, we don't care if you think Sandra Birchmore was dishonest. We will look at the substance of what she claimed itself and see if it can be validated in other ways. And so here are some of the ways that it can be validated. We don't get to see, of course, the details of the text messages, but quite a few of them, quite a few of them here that we don't get to look at. Some footnotes. The message exchange suggests that Devine and SB were communicating via Facebook message well over a year prior to the alleged conversations between SB and Marty Riggs. The conversation thus also supports that Devine was untruthful when he testified that he did not have an active Facebook account during a period including 2019 through 2021. And then Chief McNamara testified that Robert Devine goes by the nickname Rob and that the other individual with the name Robert at SBPD does not. Yeah, we remember that. So this is going to something in these messages that we don't get to see. But look, there's quite a lot of them where she is talking to other people and she's naming these three apparently as as her sexual partners at SPD, and gave these descriptions of the December 21st, 2020 incident with Devine. A lot of text there that he's citing in support of that. The division argues that based on context, blank is a likely acronym for blank. While that is a possibility, the hearing officer is unable to accept that as fact. In any event, the evidence establishes that at the time of this conversation, the respondent lived with his two children, including a son, neither of whom was an infant. This may be one of the instances where SB fabricated a sexual encounter. So what he seems to be saying is that she may have like bragged about her conquests or whatever. She may have played up a little bit more than what actually happened, but there is enough here to establish that she was consistent about, at the very least, the December 21st incident and the fact that they had a sexual relationship at all. And so those are enough for him to accept that, even if she'd like to maybe, play fast and loose with the details of what exactly they did or something like that. Heel, a former animal control officer, admitted during an interview with the investigators to a single sexual encounter with SB, despite his earlier claims that he had had no such encounter. Heel confirmed that SB had told him that she had been having sexual relationships with three other officers at SPD, Matthew Farwell, William Farwell, and Devine. Although several of Heel's statements suggest that he was at times untruthful, his statements are consistent with SB's claims that she had sexual relationships with the four SPD employees. Devine argues that the inadequate investigation by the SPD, the failure to include certain exculpatory evidence in 2021 Internal Affairs report, and the bias of its author, Deputy Chief Holmes, require that the findings of the report be rejected. Despite the length of the report and the investigation itself, the extensive analysis of the data extracted from SB's computer and cell phone, the number of interviews conducted by the investigators, and the use of two investigators from outside the SPD assisting in the investigation, there were significant deficiencies in the investigation. So he's going to now address this second. We've done away with your argument that it's not credible to believe he's Marty Riggs. Hearing officers like, yeah, it's credible for all of these gazillion reasons. So now we're moving on to the investigation itself wasn't fair. So there were significant deficiencies. Most notable was the failure to subpoena records from Facebook, even though Holmes specifically recommends that the commission do just that. So why did you redact his recommendation earlier when now you're telling us what that recommendation was? Like what was the point of that? I don't know. So he recommended that the commission subpoena records from Facebook, and they couldn't be bothered to do that. Unfortunate. Really speaks to the priority that they gave to Sandra, doesn't it? From the outset. Devine claims that this omission is particularly fatal because there is an absence of evidence that he ever had a Facebook account during the relevant time period, or that he ever had a Facebook Messenger account at all. The failure of both the SPD and division to attempt to secure records from Facebook does not, of course, mean that the respondent did not have a Facebook Messenger account or access to one during the relevant time period. The August 2022 list of his applications appearing on a screenshot that was introduced by the respondent in evidence does not reflect an active Facebook account at the time, although he had one in at least 2010, and does not reveal that there was ever a Facebook Messenger account. Nevertheless, these lists do not resolve the issue, as it appears that the list can be edited by the user of an iPhone, and Devine created the list himself. Couple of footnotes here. There is an issue of whether the list admitted in evidence, Devine's Exhibit 7, was the same list provided to the SPD, which casts some doubt on the probative value of that evidence. There were disparities in the dates of these versions, as well as with the number of applications on an updated version provided to the Commission in 2023. Neither version, however, revealed a Facebook Messenger account. No evidence was presented at the hearing whether, at the time in question, Facebook messaging could be accomplished with only Facebook and not a Facebook messaging account. It's true, they only asked him. They didn't present affirmative evidence that that was the case. And then here's a nice, he finds his own link. According to Apple's website, an application can be hidden from a user's purchase history in just a few steps. How to do it. There's a whole Apple support article apparently on how to hide your purchases from the App Store. Oh, I don't even want to think about why there would be consumer demand for such a thing. Why would you need to conceal? Oh, and the fact that Apple is servicing that, kind of gross. The respondent maintains that the results of the 2021-2022 SPD Internal Affairs investigation were heavily influenced by the biases of then Deputy Chief Holmes and Chief Donna McNamara. His code provides in pertinent part, the investigator from the agency performing the internal investigation shall be free from conflict of interest, bias, prejudice, or self-interest, and shall report for the purpose of the investigation directly to the head of the agency or to a designated official immediately subordinate to the head of the agency, unless the head of the agency or immediate subordinate is the subject of or implicated by the complaint, or is otherwise unable to supervise the investigator due to conflicts of interest or the potential for bias, prejudice, or self-interest, whether apparent or perceived. There is nothing in the record to support a finding that Chief McNamara had a bias against the respondent or acted with a conflict of interest. Bias when it comes to law enforcement and prosecutors, it just gets treated extremely differently than it does when you're talking about lawyers. This is something I'm going to be doing a little bit more about this in the coming days, because it's something that I've been looking into in a couple different contexts. We've got in the Tyler Robinson case, he's arguing to disqualify the prosecutors based on a conflict of interest. And then also Mickey Steins is arguing that the judge needs to be disqualified because he sat next to Judge Mullins at a meeting, apparently like a couple days before the shooting. So I've been doing some kind of digging into these types of conflicts and, the extent to which they're found to exist, and what kinds of standards get applied to them, and so forth. And the general takeaway is that it's just extremely generous when it isn't something that's really crystal clear, like you are the complainant You're the one who is like the victim in the situation, then like, yeah, no, you don't get to be involved in the investigation of the perpetrator, which is exactly how Robert Devine ran afoul of that conflict of interest policy and got that adverse finding from the 2014 investigation. And things like, you have a direct financial interest in like the business that is the defendant in the case before you. No, you don't get to serve as the judge in that particular situation. But when it gets to, personal things that aren't explicitly like, this is a family member, this is my wife, this is my father, this is my child, and it starts to get a little bit more collateral, a lot harder to establish that there's going to be a problem with that type of relationship. So I just offered that by way of context as something to be aware of. I've been looking into it. It will be coming out in a little bit more detail about that. But obviously implicated here with the argument that that Chief McNamara and Brian Holmes had these conflicts of interest because they didn't like him. So no evidence of McNamara having a bias. While SPD initially failed to submit a comprehensive copy of the 2021-2022 internal affairs investigation to the commission, leaving out recordings and transcripts of certain interviews conducted by the investigators, it does not appear that omission was intentional. This was the shit show that caused the hearing to get kicked from June out to July because they discovered, all of this stuff that was part of the investigation had never been turned over in discovery. So they had to do that. They were located by Chief McNamara during the hearing and promptly produced, and the respondent was provided with an opportunity over several weeks to review the materials omitted. Nor does the record suggest that their failure to disclose all exhibits was intentional or designed to prejudice Devine, and none of the evidence supports that the bias of Holmes ultimately had any impact on the outcome of the SPD investigation. So conceding here that there is bias on the part of Holmes, the hearing officer is saying Holmes was biased, but harmless error didn't affect his decision-making. So now we're going to flesh out the details of Holmes's bias. There was a curious incident. Here's that curious again. Curiously, works out convenient for Devine that he's getting hacked for 5 years, all the way back when he had his first IA investigation through this one. Quite convenient for him, curiously so. It was not so curious. Is this one really curious? I don't know how curious this one is either, but he's being generous. A curious incident where Robert Devine's 8-year-old daughter was found to have placed a troubling letter in Holmes's mailbox in the police station department approximately in 2016 after the respondent returned to work following his suspension. Devine testified that his daughter of her own volition wrote a note to Holmes stating, "Revenge is a dish best served cold," which is a quotation from a movie. According to Devine, his daughter had targeted Holmes because Holmes was now the deputy chief, which was Devine's previous position. Now, why would she be so filled with envy and jealousy of Holmes over taking daddy's job? Unless she heard that from daddy? Really got to kind of wonder about that. Don't think it would really cross your mind as a kid to just assume there was something nefarious going on, because your daddy, of course, took accountability for what he did. It's a very important theme of this case now in front of the hearing officer, that he took accountability for what he did in 2015. And so therefore, we have to assume that he understood punishment was appropriate and inevitable. Why is an 8-year-old girl going to be like, he took my daddy's job? Like, sorry, you were told that. Sorry, not sorry. McNamara ordered an investigation after Holmes brought the matter to her attention, the result of which was that a no trespass order from the station was issued against the daughter. Yeah, if you're going to throw your daughter under the bus, then she's going to suffer the consequences. That's how that works. That's how that works, Mr. Devine. But that, for him, just becomes another source of grievance, right? They're so mean to my daughter. Well, do you not see how this would be inappropriate behavior for your daughter to be mad at Holmes for taking daddy's job and leaving a vaguely threatening message in his mailbox? Are we no longer in our era of taking accountability for our wrongdoing? Because I would think that most parents would be alarmed by this and would, if not take the initiative to do some of their own discipline, or at least talking it out with the child, appreciate that people who are affected by this are not in the wrong. They didn't do anything wrong. Holmes didn't do anything wrong here. McNamara didn't do anything wrong here. The source of the wrong is whoever stuck the note in Holmes's mailbox. And you wanted to blame your daughter, so that means it's going to be her. But of course, that's not going to be good enough. That's just a source for more victimization. Given his daughter's age at the time, it would not have been unreasonable. This is a really nice way to put it. For Holmes to believe that the note came from Devine. Yeah, it's not really a big leap of logic to think that the blame shifting is a bunch of crap that's just consistent with what this guy does and has done from the beginning. He points the fingers at other people and then plays the victim. And he used his own daughter to do that. Not really a big stretch to think that that's what went down here. Really nice way to put that. In any event, there is nothing to suggest that the incident created a conflict of interest or evidenced a bias on the part of McNamara. McNamara acknowledged that she was aware of a rift in the relationship between Holmes and Devine, and while it might have been more prudent to have appointed another officer to conduct the 2021 investigation, to avoid the potential appearance of a conflict of interest, as discussed below, it does not appear that she would have been aware of an actual conflict that prevented Holmes from performing the task objectively. So the fact that she took his word for it and said, okay, you say it's your daughter, then we'll act accordingly. We'll treat it as though it came from your daughter, and we will remove her from the station to eliminate any further disruption like that. She doesn't really have any business here anyway, being an 8-year-old child. Yeah, that didn't create a bias on her part. I mean, some of this stuff, it's so bizarro reasoning. It only makes sense to somebody who in their mind thinks that you have to believe what they say just because they say it. That it's just, I can't kind of wrap my head around how you think this makes sense as a logical proposition, that this makes her biased because she believed you. I'm not getting that. McNamara played a limited role in the procedure of the 2021 internal affairs investigation outside of making the final decisions. She confirmed that she agreed with the findings of the internal affairs report after her review, although she candidly admitted not having read it in its entirety. And had Devine not retired prior to its conclusion, she would have recommended his termination. She also confirmed her recommendation to the commission for Devine's decertification. Given Devine's significant misconduct relating to SB and his previous discipline from 2015, McNamara's conclusions and recommendations were reasonable. Yeah, they were. On no planet does this guy qualify for a badge. The fact that he has a law license at this point is appalling. Nothing in her testimony indicated that McNamara harbored any personal feelings against Devine or that she believed the relationship between Holmes and Devine prevented Holmes from conducting an unbiased investigation. No, this was all projection on Devine's part, wasn't it? He's jealous as hell of all of these people because he's got this unrestrained entitlement. He thinks he should have gotten that job, right? And it's the total unfairness that he got demoted and these other people got to jump the line ahead of him and take what was rightfully his, right? He's just exceedingly jealous and resentful of them. And so he projects that on them. They hate me. Well, no. And the logic doesn't follow. And you would see that if you weren't so poisoned by your own envy and resentment and your arrogance in thinking that just because you're projecting means that we're obligated to accept that as reality. Holmes testified that he has known Devine since their time together at the police academy in 1999. They remained close early in their careers and occasionally socialized outside of work until about 2011 over an issue relating to Devine's refusal to testify on behalf of a member of the SPD. Their relationship became further strained following Devine's 2015 internal affairs discipline. Holmes described Devine as a misogynist and did not approve of him stepping out on his wife. Holmes claimed that these personal views did not impact his professional objectivity. Holmes was assigned to conduct the 2021 internal affairs investigation after MSP informed Chief McNamara of a potential relationship between Matthew Farwell and SB. Although, as noted, the investigation initially focused solely on Matthew Farwell, digital data extracted from SB's devices expanded its scope to include other officers, including Devine. After Devine became a subject of the investigation, Holmes considered recusing himself. He testified that he was not biased against the respondent, but recognizing that he would claim bias, he had the former members of the MSP assisting in the investigation conduct the interviews of Devine. Holmes received digital evidence from MSP and analyzed it using Celebrite and Blacklight to extract data, which included messages, photographs, and other digital files from SB's electronic devices. Investigators interviewed Devine and other relevant witnesses, in part using the data analyzed from SB's phone to pursue investigative leads. Mentions of blank. This is a short word. I'm guessing it's Rob. Mentions of blank in SB's communications increased the scope of the investigation to include Devine. Holmes later made the connection between Marty Riggs, who was communicating with SB through Facebook Messenger, and Devine. Holmes made the conclusion based on the fact that Marty Riggs and Devine were both attorneys, that they were both police officers, and that Marty Riggs planned to meet with SB while on duty at times Devine was on duty, and that the username for Marty Riggs was Hot Guy Robbie Devine. What is it? What is it? Robbie D, you know you want me. Holmes should have recused himself from the investigation once Devine became a subject of it. His use of the MSP investigators to conduct an interview of the respondent was admittedly an effort to undermine any claim by Devine of bias, rather than being probative of the absence of actual bias. The question remains whether there is any indication in the 2021 Internal Affairs report or in the evidence adduced at the hearing that any bias he harbored towards Devine impacted Holmes's ability to conduct an objective investigation or the result of the investigation. So him saying, I'm going to take these protective measures so he doesn't accuse me of bias is not proving that nevertheless you weren't biased. So he's not saying, the hearing officer is not saying he was biased, but he is saying that bias hasn't been, disproven. But it didn't affect the outcome. Respondent points to several examples of alleged prejudice he has suffered as the result of Holmes's bias, such as 1, the failure of Holmes to include what he maintains to be exculpatory evidence addressed earlier in this decision; 2, the misquoting of Devine's response in his interviewer's remark that the investigator had not found any evidence of direct communication with Devine; 3, an inaccurate description of an incident described by Detective William Tracy; and 4, the emphasis in the report of the incident relating to blank. So we have some footnotes here that are redacted that make it hard to understand what exactly it's about. But apparently in the 2021 Internal Affairs report, Holmes claims that something in his interview, this appears to be an example of Holmes's misuse of some essentially innocuous testimony by mischaracterizing it. So it sounds like, people told him things and he looked at it in the worst possible light. It's what it sounds like. Then the next one, somebody came forward with a story claiming that the respondent acted inappropriately towards her when she was blank. It's included in the Internal Affairs report. This has got to be the gym incident. The respondent submitted the affidavit of blank, a friend of Devine's. Respondent is critical of Holmes's inclusion of Tracy's report of his discussion with her, describing it as an effort to further a false narrative and inflame. If that was the intent, it failed, as the division did not allege any misconduct in relation to blank, and the SPD did not sustain any charges relating to his alleged conduct towards blank. This is, got to be the gym incident, because we know that came up, and he had that whole explanation about that too. That was the horrifying part about how, she's obsessed with him and he didn't take that to her parents. And then supposedly her mom wants him to talk to her because of it. And it was all just displayed a horrifying lack of concern for the emotional well-being of this child. So anyway, those are just I guess the examples of why he says that there is bias here. So as to two being misquoting of Devine's response to his interviewer's remark that the investigator had not found any evidence of direct communication with Devine. As to 2, Holmes wrote in his report that Devine responded blank, by implying, according to respondent's argument, that something exists, but it is hidden. In a transcript of that interview belatedly produced by SPD to the commission, it states in bold letters that the actual response was blank. Respondent argues in his post-hearing brief that his actual response conveys that there is nothing to be found, that nothing exists to be found. Holmes acknowledged in his testimony that those words have different meanings. Even assuming but not finding that this misquoting of respondent provides evidence of Holmes's bias because it was an intentional choice to use an arguably more inculpatory word in his report than the word he knew that Devine used, either version supports the conclusion that the respondent was untruthful in his interview, because the evidence supports the conclusion that he in fact had direct communication with SB. It is no different than his repeated untruthful direct denials of having communicated with SB using the Facebook alias Marty Riggs and communicating with her on social media. Here is the classic example of the whole nitpicky around the edges on stuff that doesn't even necessarily matter kind of point I was bringing up about the way that people who are just in total denial of their own responsibility and accountability will behave. He's going to nitpick. He found something that he can highlight. Ooh, look, he did this wrong. He used the wrong word. He made me look worse than it actually was. But it doesn't frickin' matter because you were still lying either way. Nobody's buying your Marty Riggs bullshit, dude. And he really thinks he's going to get somewhere if you can point out, aha, I got you. As if we don't have to keep in mind the fact that there's overwhelming evidence that you're Marty Riggs and that you're lying about all this stuff. And so why wouldn't you just be lying about this too? To the extent that Holmes had a level of bias against respondent that may have had some impact on the manner in which he presented evidence in the 2021 Internal Affairs Report. The hearing officer concludes that this bias did not impact the limited findings ultimately made against Devine. The relevant conclusions were based principally on documentary evidence and testimony, which have not been shown to have been corrupted by any bias or conflict of interest. It's what the messages say. The messages themselves. Those are what hung him. It didn't help that he came up with all of these extremely far-fetched, ridiculous explanations for the messages. And the I was hacked and just all of it. That didn't help. But the bottom line was that the messages that Marty Riggs sent to SB, that's not anything that is in the control of the investigator to create. They're just there to interpret. So you could argue the interpretation might be infected by bias, but the problem is that reasonable people agree with the interpretation because the facts are what they are. If Marty Riggs was admitted to the bar on January 11th, 2021, and his name is Rob, and he works at Stoughton Police Department, there isn't anybody else that's going to fit that description. And that's the problem that he always had and why he always had to, spin up these ridiculous explanations to try to distract from that core fact. So just another example of that. Ooh, look, squirrel. And it didn't work. Other evidence presented by the respondent lacked probative value to the issues at hand. Moreover, the circumstances surrounding the drafting of two affidavits, those of Sheridan and Hailey Hogan, for which Devine admits providing templates to the affiants, raise questions about respondents' involvement in the drafting of the documents. So I'm not quite sure how we jumped to this, but just... it lacked probative value. He didn't care if Hailey Hogan is saying, I thought Robert Devine was great. And he's like, by the way, I don't care. It doesn't matter. It doesn't mean you didn't do the things that you're alleged to have done. But also the whole situation is sus. The way that cross-examination of Hailey Hogan just crashed and burned as soon as she was asked about, have you had any contact with Robert Devine? Did you discuss this with him? And just how she struggled and fought to try not to say that, of course, she'd had communication with him. And of course, they had talked about the situation because that's why she's submitting an affidavit in the first place. Yeah, that was sus. Thank you for noticing, hearing officer. It was quite sus. Based on the evidence that conflicts with Devine's denials of his communications and sexual encounter with SB and his representation of never having had Facebook Messenger on the phone he was using to communicate with SB, the implausibility of aspects of his testimony, coupled with the suspect nature of certain evidence offered in his defense, as well as his demeanor during his testimony, the hearing officer finds that he lacks credibility in his denials of the relevant allegations against him. This paragraph right here is calling Devine a liar. You lied. You lied, and we all know you lied. Why? Because the evidence shows that you lied. Your testimony is implausible, and your whole demeanor was off-putting. It made it pretty clear that you're not to be trusted. Footnote 17 here we got to look at. This includes his role in drafting the substantive content of affidavits submitted by certain witnesses, the questionable lists of applications on his phone, and evidence of screenshots, which he implausibly claims demonstrate that he continues to be a victim of online harassment, but none of which relate to the use of Facebook Messenger, and one of which was not taken from his phone, as he claimed. Problems with his evidence that kind of make it look like he is just doing a little bit of shenanigans to deceive, mislead, misdirect the court, suggest things that are not true. So those were just some examples in that footnote. Perhaps one of the most glaring inconsistencies in his testimony relates to the critical issue of his relationship with SB. On the one hand, he portrayed SB as a former disruptive student who was always trying to get his attention. While on the other hand, he claims that he never had any meaningful contact with her and that any contact he had was purely coincidental or limited. So he didn't know her at all, but he knew her. But he knew her enough to know. Although he claimed to have concerns with SB approaching his patrol vehicle, repeatedly asking personal questions and making inappropriate sexual propositions to him, he never recorded or reported these incidents to the proper channels. Nothing but his word to say that any of that happened. Never turned on his body cam, never turned on his dash cam, didn't document any of this at all. Probably didn't even call it into dispatch, the radio, or we'd have a CAD log saying, hey, I'm being approached by a person, so that they would know at the dispatch center that you're engaged in a potentially dangerous encounter, interacting with a civilian, traffic type of encounter. Type of thing you might normally report back to your dispatch, but he didn't do a single thing like any of that, let alone, hey, this girl is approaching me inappropriately and I want to CYA in case something comes out of it. You were in law school, for heaven's sakes. You know about a CYA, but you didn't do that because at this time period, you were trying to keep everything on the down low. So it wouldn't have been consistent. You can't CYA without calling attention to the fact that this is happening, and you don't know yet that you need to account for this happening. So you're keeping it on the down low. His explanation stating that he rebuffed SB's advances while occasionally engaging in conversation so as not to be rude demonstrates a fundamental failure to maintain appropriate boundaries expected of someone in his position of authority. And this was a pattern. That's why the gym incident mattered. This was a pattern. He made it just crystal clear that he has no idea and no interest in exercising the type of authority over young girls that someone in his position should be expected to exercise. He also claimed not to know her well personally, but the evidence clearly establishes the opposite. SB had been a member of the explorers group he ran since she was age 13. She would approach him once a week while he was on duty. He interacted with her several times in the months preceding her death, and he had clear knowledge of personal aspects of her life, including her dating relationships within 6 to 8 months before she passed, what college she was attending, where she worked, her sexual relationships with William and Matthew Farwell, the fact that she was pregnant half a dozen times, and her pregnancy purportedly resulting in her relationship with Matthew Farwell. They, again, this is like they blacked out, redacted all of the specific communications earlier, but now you're just going to go ahead and tell us what they said. Like, I don't understand what this is achieving, because now we know what she said. She told him she's pregnant and that Matthew Farwell was the father. And then he asked her if they could still have sex. Like, how gross is this? As noted, he even sought to influence her not to disclose information about her pregnancy to others. Moreover, he stated he did not know her well, but somehow was aware that she exaggerated all the time. I'm trying to have it both ways. I don't know her at all, but we would also stand around the water cooler and talk shit about her nonstop. You don't get to have it both ways. The evidence from various witnesses was that SB was very, very vulnerable, blank, socially awkward, easily manipulated, and had problems with her self-esteem. Witnesses, including Devine himself in his interview, stated that she was blank with the SPD and arrived at the police station a lot. We don't get to see this word, but I'm just going to go ahead and guess. Obsessed, right? He's obsessed with the idea of people being obsessed with him. And so that would certainly fit his mental framework here. Because the above outlined evidence establishes that Devine was communicating with SB by using the Facebook alias Marty Riggs, Devine was untruthful during his interview with SPD and in his written submission to the commission about these communications. So he doubled down. This is really important, I think, from the standpoint of, should the bar be getting involved with this conduct? Because he is a licensed lawyer now when he's doing these things, when he's participating in the IA investigation, and certainly up through the point where he's getting on the stand at these hearings and testifying to stuff that they're finding is untrue under oath. Because he's doubling down, and this doesn't show, amenability to being better. It suggests a real serious defect in character related to honesty, particularly honesty about your own failings. And when it comes to being a lawyer, you really need a solid grasp on your own shortcomings so that you don't get out of your depth and so you don't screw over your clients. If you have a lawyer that's doing estate planning and they make a mistake with somebody's documents, there's two ways it can go. They can say, I made a mistake. They can try to fix it. If they don't, aren't able to fix it, sometimes you can't fix it, then it goes to your malpractice insurance. And yeah, that's going to be unpleasant for you. It's going to cause your premiums to go up. There's going to be, a finding that you committed malpractice. No lawyer wants these things. And yet, that is the right thing to do when you've made a mistake. And that's why those systems exist in the first place. That's why you have malpractice insurance. It's not coming out of your pocket. It's not that big a deal, really. It's just an ego hit that you take more than anything else. So, you can take the accountability route and do your best to fix it and make your client whole because they're not the one who messed up. Or you can go down the other route where you just deny that you did anything wrong and you lie about it and you make up excuses. And what do you think from our record this guy, Mr. Devine here, is going to do? Which type of path is he going to go down, do you think? It's pretty freaking obvious, isn't it? This guy is a menace to potential clients because he cannot be trusted to be forthcoming about his own failings, to put his client's interests ahead of his own. So the doubling down, they should be taking that extremely seriously because that is so damning, such a problem for this guy's ability to do the kinds of things that lawyers have to do. Despite several questions aimed at determining the true nature of the relationship between Devine and SB, Devine never disclosed that he had any sexual encounters with SB. Similarly, in his written submission to the commission, Devine was adamant that he blank and that blank. Don't know what those are, but think that said he's not Marty Riggs and that he never had any communications with Sandra because that's what he said in the IA and that's what he's doubled down on. And the hearing officer doesn't buy it at all. So accordingly, the hearing officer finds that there is clear and convincing evidence that the Stoughton Police Department correctly sustained the allegations of truthfulness against Devine. So even if Brian Holmes was biased, even if he should have backed out of the investigation, even if the investigation was deficient in, ways that they would prefer that it wasn't, because you could have gotten more definitive evidence of whether or not he was Marty Riggs and you didn't do that. Nevertheless, there's enough with what they have to reach the conclusion, yeah, you are Marty Riggs and you lied about it. And because of that, you're not fit to be a police officer. You're not fit to be a lawyer either, but that's going to require a separate process. Statutory and regulatory basis for commission action. So this is now his legal analysis, and I'm not going to go through and read all of these codes, but I am just going to get to the bottom line here. The hearing officer notes that the burden of proof lies on the division to prove their bases for revocation of the respondent's certification is clear and convincing evidence. So higher standard than the just preponderance. You need more than just more likely than not, everything else being equal. I tilt a little bit this way. You have to be a lot more firmly convinced that the commission is right. He thinks it meets that standard. Recommendation based on the evidence and the applicable statutes and regulations. The hearing officer finds that the division proved by clear and convincing evidence that the respondent engaged in a pattern of unprofessional police conduct that may escalate, that he has been untruthful. I really like that he made this a specific finding. This is a retired judge. He knows what the standards are for practicing lawyers. He knows that dishonest conduct affecting, your ability to be a lawyer is something to be deeply concerned about. We cannot just sort of like brush this under the rug or euphemize it or something like that. Going to call it out explicitly. He's been untruthful. And then he has repeated sustained internal affairs complaints for the same or different offenses. As a result, he should be decertified and his information should be forwarded to the National Decertification Index as required by statute. The sustained allegations resulting from Devine's late 2014 misconduct are undisputed. Devine admitted to the underlying facts when he testified, and nothing presented at the hearing undermines the hearing officer's confidence in the outcome of that internal affairs investigation. At the time of his misconduct, his indiscretions warranted several sustained charges, a 60-day suspension, and a demotion from deputy chief to patrol officer. Devine's conduct in 2014 demonstrated that he is willing to abuse his power for personal gain and to be untruthful when it benefits him. Despite the fact that respondent had no disciplinary incidents in his first 15 years in law enforcement, his misconduct seriously escalated even further in late 2020 through early 2021. As noted, the division established by clear and convincing evidence that Devine was communicating with SB while on duty on several occasions, and on at least one occasion met with SB for a sexual encounter. Thereafter, he lied to investigators when he denied engaging in these conversations and the sexual encounter. He then reiterated these untruths in his sworn testimony during the adjudicatory hearing. Again, important to call out because this is perjury. This is not just, I lied to my wife or whatever, which is bad enough. This is perjury, sworn testimony by somebody who is supposed to be an officer of the court. These findings are seriously exacerbated by the fact that the respondent was in a position of power over SB when he met her as a middle school student and thereafter when she was a police explorer. Particularly given her vulnerabilities, he was able to maintain that position over her for several years and leveraged this position to develop a relationship with SB, which eventually became sexual. Once again, Devine exploited his position of power within the police department and was untruthful when it benefited him. Almost like there's a pattern here or something like that. Despite that the information he concealed may have been relevant to the investigation of SB's death, Devine lied to protect himself and his reputation. The hearing officer concludes that the respondent's pattern of unprofessional conduct may escalate. Over the last several years of his career, his interest in his reputation and what benefited him far outweighed any concern he had for the public interest. Oh, there's that just dripping jealousy and contempt and insubordination. From the moment he went back to that police department and had to work in his inferior status, he could not put that aside. He just couldn't do it. He couldn't be a team player. I mean, I remember listening to this testimony and thinking, God, what a nightmare. What an absolute nightmare this guy was. You just know. Every time he walks by Brian Holmes, he's like, he's my job. I should be my office. That was my office before. It was so unfair. I can't believe they, you can just hear his little like internal voice. And all just the little ways that would have manifested, the little undermining, the little unsubordinations, all the way up to the big ones, that they had to do something about, like when he was off-road duty and decided to go respond to the call anyway. Yeah, he didn't play for the team. He didn't put his own interests aside in order to, follow the decisions of his superiors at the Stoughton Police Department. He put his own ego first. It's crystal clear. As a result of the internal affairs investigation relating to Devine's unprofessional conduct in 2020 and 2021, SPD again sustained multiple internal affairs complaints against him. So, yeah, we've got a pattern of conduct here, 2 times in 5-6 years, resulting in findings both times. Both of them showing you're really unsuited for this type of trust that the public gives you when they give you a badge and a gun and the power to arrest and search and do all the things that the police officers are able to do. You don't deserve that. You can't be trusted with it. So then notice of the 30-day right for review is just a formal notice here that they get to object and send it up to the commission, and the commission can then review it. And we, of course, know that did indeed happen, because that's what led to the delay in us getting this decision, and the commission ultimately entering its final decision, where they upheld everything that the hearing officer found, agreed with it, and did not do anything to limit or undermine in any way the conclusions and the recommendations that he reached. Adopted it in full, and so, yep, Robert Devine is decertified. So well deserved, very well deserved. I wonder how clear he feels his name has been by now. Now that all of this is out here and the whole world gets to know, all of these people know that you lied. Everybody knows you lied. And you're suffering consequences because you lied. And you're a chronic liar, by the way, because you lied back in 2014, 2015. And here you are lying again. All because you're just allergic to taking any accountability for what you do. And then you demonstrated that in living color in your own testimony at your own hearing that you asked for. There will never be any kind of, reflection on any of this, on his choices in any of it. He will continue to maintain, that he's the victim in all of this. It's just a grave injustice. It's so unfair. He will continue to deny all of this until he's not in a position to deny anything at all anymore. And at the end of the day, it doesn't matter, because, we see who he is now. We see who he is. The hearing officer clearly saw, the commission saw, and now the world at large gets to see everything that they saw about this guy. And so now all we can do is just hope that perhaps the bar examiners will take a look at themselves, see what they think, and see if they like what they see under all these circumstances. So, fingers crossed. Well, guys, that was just that was a little bonus, a little extra fun, wasn't it? Getting to see that little bit of snark in there. Hearing officer making it clear, even though most of the time he's going to say the bad stuff in the nicest way possible, you're absolutely full of shit. He doesn't quite say it like that, but it really comes through really loud and clear. Your explanation about your hacking is curiously convenient. He sees right through all of it. Right through all of it. Very, very polite with it, but quite damning, the things that he had to say. So hopefully, guys, you enjoyed this little walk through the hearing examiner's decision. Little extra celebration here to get to see exactly why. To the extent we get to see, of course, with all the redactions still, but exactly why they thought, yeah, this guy's a lying liar who lies. Doesn't deserve to be a police officer in Massachusetts or anywhere in the country. Oh, he saw it the way we did. I was. You just always a little bit worried about are they going to bend over backwards because this is a police officer? Just yes, I'm a defense lawyer and I'm a little jaded and black-pilled about how those types of things go. But it's not for a lack of reason. It's not in the absence of any kind of experience of those types of things happening. It's just all too common that police officers get the benefit of the doubt, and their word becomes the law. If they say that it's the case, then there's just a all too common lack of willingness to look real deeply beneath the surface and really question the credibility and veracity of police officers. So to see that in a case like this, now maybe it takes something this overt and this obvious for that type of thing to happen, for the hearing officer to be like, do you really think I'm stupid? Do you really think I'm that stupid? You really do think you're the smartest guy in the room, don't you? And nobody's buying it. Nobody's buying it. Maybe it takes something that overt to get here, but I don't know. I gotta tell you, it's a bit of a relief every time that I do see the right outcome. The right thing has happened here. We saw it from the hearing. We're not delusional. We're not going to be gaslit about about our experience and evaluating what this guy had to say and how he had to say it. And so it is always validating when the person with the authority, the person whose opinion about it all actually matters, because it can contribute to the outcome when they see it the way that we do. So yeah, guys, life is good. Still waiting to see if he's going to challenge this in Superior Court. He's got, I think, a couple more weeks to be able to do that. So we'll see. We'll see if he goes down that road. But otherwise, if he doesn't, this is going to be the end of it. So nothing to do but tick tock. Wait for the timeline to run out and see what happens. So, guys, hope you enjoyed this little bonus as much as I did. Yeah. The heat he brought is definitely there. Definitely there in that opinion. So with that, guys, I already gave you a little bit of a clue about some things I've been working on relating to conflicts and things like that. But it's been kind of a dreary, dark winter here. I'm not going anywhere special this year, not going down to South America or anything like that. So it's a good time to be following cases, making content and stuff like that. I've got a lot coming out on Substack. Big plans for more videos and things like that on YouTube. So do stay tuned if you are so inclined. Got some stuff coming up in the Matthew Farwell prosecution as well, as far as Sandra Birchmore goes. So plenty of stuff to watch. I will be covering it. And yeah, hopefully this isn't the last good outcome we see for a while. So with that, guys, thank you all for joining me. Appreciate you, your interest in the case, your support, and your interest in seeing that justice is done, not just in Sandra Birchmore's case, but really in every case. So that is the most important thing that we're trying to accomplish in our justice system, and that's why it's important to watch it so closely to see if we're getting that outcome. Guys, I will plan to see you next time. Thank you so much, and hey, Happy New Year.